In the 1980s, after Watergate, one could not help but think of what it must have meant to be a besieged president in the highest office, with all calling for your immediate removal, when hearing the words of William Shakespeare's Richard II sounding, "You may my crown and state depose, but my griefs still am I king of those." And these are interesting words even today, as impeachment is once again in the air. A new Hill-Harris X survey on Friday found support for impeachment proceedings against the president has risen 12 points compared to similar polls conducted 3 months ago, according to Tess Bond of The Hill. Also, Stephen Shepard of Politico wrote, the poll, which began after House Speaker Nancy Pelosi announced her support for impeachment proceedings on Tuesday, shows 43% of voters think Congress should begin the process of impeachment, while an equal number of poll respondents say Congress shouldn't begin impeachment proceedings. And these days it appears that everyone has declared themselves an expert on impeachment. But anyone with experience in politics knows that that which we believe we know is not always the gospel, and what we don't know can hurt us, as governments are instituted among men, deriving their just powers from the consent of the governed, according to the Declaration of Independence. And whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles as organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. And a Virginian who penned these words concluded, when a long train of abuses and usurpations, pursuing invariably the same object, offenses are designed to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. But still yet he cautioned, a decent respect to the opinions of mankind requires that they should at least declare the causes which impel them to the separation. Indeed, since the founding of a new nation, conceived in liberty and dedicated to the proposition that all men are created equal, as Lincoln said, there was expressed great concern about the passions of the common man, and a fear as to whether that nation or any nation so conceived and so dedicated can long endure. A concern summarized by one of its most admired, Dr. Benjamin Franklin, when he gave answer to a woman about the type of government that had been established. A republic, if you can keep it. Nor did this concern prayerfully tempered by the conduct of a moral and religious people, as John Adams noted in his address to the militia of Massachusetts, as its formation documents were deemed to be wholly inadequate to the government of any other, limited itself to those perhaps not even originally vested with the franchise, nor endowed with the qualifications to hold office, causing one of an intelligentsia class to warn the interests of man must be connected with the constitutional rights of the place. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections of human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place oblige it to control itself. A dependence on the people is no doubt the primary control on the government. But experience has taught mankind the necessity of auxiliary precautions, according to James Madison in Federalist 51. Those on one side of the ideological divide often find opportunity to rely on the words of one of the founders to curb religious zeal of the masses on the other side, something we see too often today, choosing only one select phrase, unintelligible propositions. But that disparagement in origin is misapplied and not directed at the entirety of Christendom, as much as those false prophets amongst them, as is easily discernible in review of the entire context of his argument, respectfully posited thusly. Although I rarely waste time in reading on theological subjects, as mangled by our pseudo-Christians, yet I can readily suppose basilistos may be amusing. Ridiculing is the only weapon which can be used against unintelligible propositions. Ideas must be distinct before reason can act upon them. And no man ever had a distinct idea of the Trinity. It is the mere abracadabra of the mountebanks, calling themselves the priests of Jesus. If it could be understood, it would not answer their purpose. Their security is in their faculty of shedding darkness, like the cuttlefish, through the element in which they move and making it impenetrable to the eye of a pursuing enemy. And there they will skulk until some rational creed can occupy the void which the obliteration of their duperies would leave in the minds of our honest and unsuspecting brethren. Whenever this shall take place, I believe that Christianism may be universal and eternal. I salute you with great esteem and respect. Thomas Jefferson. Yet, few incensed by emotion pause in reflection and introspection to ask honestly, why can't we all just get along? The actual phrase, of course, is, people, I just want to say, we can all get along. Nor to adumbrate upon the theological subjects, which hypocritically and contradictorily even Jefferson confessed in argument about proper understanding to ignore, as to propose in inquiry. And why beholdest thou the mote that is in thy brother's eye, but considerest not the beam that is in thine own, as we find in the book of Matthew. Yet reminding all of the popular adage that your friends noticed that you needed to attend to personal hygiene long before you noticed your own body odor, a visitor to America saw clearly these imperfections amongst us, often missed by those engaged in partisan professions of piety. Thusly, I never met in America with any citizen so poor as not to cast a glance of hope and envy on the enjoyments of the rich, or whose imagination did not possess itself by anticipation of those good things, which fate still obstinately withheld from us. On the other hand, I never perceived amongst their wealthier inhabitants of the United States that proud contempt of physical gratification which is sometimes to be met with even in the most opulent and dissolute aristocracy. Most of these wealthy persons were once poor. They have felt the sting of want. They were long a prey to adverse fortunes. And now that the victory is won, the passions which accompanied the contest have survived it. Their minds are, as it were, intoxicated by the small enjoyments which they have pursued for 40 years. Not but that in the United States, as elsewhere, there are a certain number of wealthy persons who, having come into their property by inheritance, possess without exertion an opulence they have not earned. But even these men are not less devotedly attached to the pleasures of material life. The love of well-being has now become the predominant taste of the nation. The great current of man's passions runs in that channel and sweeps everything along in its course. course, Alexis de Tocqueville. And for those not familiar with the law, impeachment is actually a legal term of art, generally arising in courts when there is an attempt to exclude testimony upon evidence of bad character, as we find in Gaglione v. Cobb, a Virginia case in 2008 that is based upon Brady v. Maryland, from which we get the Brady Rule evidence, which many of the founders as attorneys knew or should have known, as attorneys say. And terms of art, by definition, are those words and phrases that often have a popular legacy in the minds of a plebiscite layman that may impute some of the normal associations for the common man, but which carry uniquely refined distinctions of legal significance in the operation of law, like the term assault, which to the average Joe and Josephine includes the legally significant act of battery, but which is bifurcated as a tortious offense in the law. And I would posit, based upon our best compilation of legislative history on the topic, specifically the works of Alexander Hamilton in Federalist numbers 65, 66, 79, 81, that the best understanding of impeachment, or most specifically the high crimes and misdemeanors noted in Article 2, Section 4 of the U.S. Constitution, is to consider it analogous to a civil proceeding commenced under the Racketeering and Corrupt Organizations Act, RICO, codified at 18 U.S.C. Sections 1961 to 1968, which provides a civil forum in courts for predicate offenses that are criminal in character, requiring nonetheless establishment of proof for criminal conduct therein beyond a reasonable doubt, and not just the looks-a-lot-like evidentiary standard of proof, not acceptable in any court of law, and thus not satisfying any constitutional threshold for the deprivation of life, liberty, or property in due process, as we find in the 5th and 14th Amendments. It is a basic maxim that should be understood by all that in a rule of law, as established in a land called America, the Due Process Clause requires that every man shall have the protection of his day in court. That was a case, Truax v. Corrigan, decided by the United States Supreme Court in 1921. And due process is the process that is due under particular circumstances and does not invariably mandate trial-type proceedings. A quote we find in Secretary of Labor v. T.P. Mining, a 1986 case, but oft repeated. This refined approach to RICO was considered only within recent years in Spinelli, Cahill and Berkman, S.A. v. Imus Gruner, AIA and Associates, a 1985 Maryland case in the Federal District Court, when considering the available evidentiary standards of proof, i.e., proof beyond reasonable doubt, proof by clear and convincing evidence, and proof by a preponderance of evidence. Noted the words of the court in Sedema SPRL v. Imrex, a Second Circuit case from 1984, that courts, in addition, have indicated that probable cause must be alleged with reference to predicate acts, although how this is meant to relate to the burden of proof of the plaintiff at trial remains something of a mystery. And that court reached this conclusion. The most logical conclusion to be drawn is that Congress expected the criminality of the predicate acts to be proven before the private action went forward, that a criminal conviction must precede a private civil suit. And multiple courts have reaffirmed this rule, but not necessarily required the actual criminal conviction first. U.S. v. Palullo, any violation of 18 U.S.C. 1962 must be proved beyond a reasonable doubt. U.S. v. Mensa, a Second Circuit case from 2003, quoting U.S. v. Karakaba, a Second Circuit case from 2010, stated, To prevail on an insufficiency of the evidence claim under Rule 29, a defendant bears the heavy burden of showing that no rational trier of fact could have found all of the elements of the crime beyond a reasonable doubt. U.S. v. Gio, a Second Circuit case from 2013, quoting U.S. v. Espelette, a Second Circuit case from 2004, wrote, "In other words, a judgment of acquittal is warranted only if the evidence that the defendant committed the crime alleged is non-existent or so meager that no reasonable jury could find guilt beyond a reasonable doubt." Yet confusion has existed on this topic of the burden of proof required for impeachment from the earliest days, as even Hamilton anticipated that the impeachment process would be politically divisive, with allegiances aligning with partisan loyalties, fixated upon feelings and not focused on facts. As he writes in Federal 65, the subjects of its jurisdiction are those offenses, a legal term, which proceed from the misconduct of public men, or in other words, the abuse or violation of some public trust. They are of a nature which may, with peculiar propriety, be denominated political, as they relate chiefly to injuries done immediately to the society itself. The prosecution of them, for this reason, will seldom fail to agitate the passions of the whole community, and to divide it into parties more or less friendly or inimical to the accused. In many cases, it will connect itself with pre-existing factions and will enlist all their animosities, partialities, influence, and interest on one side or on the other. And in such cases, there will always be the greatest danger that the decision will be regulated more by the comparative strength of parties than by the real demonstration of innocence or guilt. Again, these are legally significant terms that Hamilton uses, which could only apply to crimes. While a recent article parsing the meaning of high crimes and misdemeanors, ironically relying upon the authority of the federal inspectors, but nonetheless exhorting others not to read that source document, erroneously states that impeachment is a national inquest. To build an argument antithetical to this one, requiring criminal conduct as a predicate offense. It's Michael Stokes Paulson in the Law and Liberty magazine in August 2018. Au contraire, I would encourage him and others to ignore that prohibition and return to the words, the exact words of Hamilton, who specifically stated what it may be asked is the true spirit of the institution itself. Is it not designed as a method of national inquest into the conduct of public men? Like civil cases arising under the RICO Act, the provocative nature of its invocation tends to incite great passions, corrupting the clinical inquiry required in a jurisprudential process, which should be immune from strictly normative value assessments and reserved to rational and sound legal argument. And the court have crisply, clearly, and succinctly described the frenzied environmental context in which all of these allegations arise in RICO thusly. Courts have described civil RICO as an unusually potent weapon, the litigation equivalent of a thermonuclear device. Because the mere assertion of a RICO claim has an almost inevitable stigmatizing effect on those named as defendants, courts should strive to flush out frivolous RICO allegations at an early stage of the litigation. Indeed, although civil RICO may be a potent weapon, plaintiffs wielding RICO almost always miss the mark. Accordingly, courts have expressed skepticism towards civil RICO claims. And in finding analogous guidance from the ever-increasing body of jurisprudence in RICO actions, it is significant that Hamilton expressly states, as emphasized above, that the subjects of its jurisdiction are those offenses which proceed from the misconduct of public men. If the exact words used in the Constitution alone are not sufficient guide to articulate a bright line rule, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, a crime, bribery, a crime, or other high crimes and misdemeanors. United States Constitution, Article 2, Section 4. Legally and grammatically separate and distinct from the proviso that the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. U.S. Constitution, Article 3, Section 1. And these words, probably owing to the partisan nature of the inquest, have historically been ignored in every attempt to impeach a president. Regrettably. Moreover, this caveat is important because even when writing about impeachment in the Federalist Papers, it is noted that the Supreme Court was expressly not chosen to have jurisdiction over these crimes, but rather the Senate, separating the impeachment convictions from the actual criminal convictions. Otherwise, there would be a double jeopardy problem under the Constitution for the actual prosecution of the crimes. This is basic jurisprudence that any first-year law student should know. And in 1868, the Congress brought a total of 11 articles of impeachment against the Democrat Party, former vice president, who had been elected to serve under the Republican president when he assumed the presidency himself. Proceedings of the Senate sitting for the trial of Andrew Johnson on February 24, 1868, found in the first article that the Congress cited that he had been unmindful of the high duties of his office, of his oath of office, and of the requirements of the Constitution, which may indeed be horrendous, but not under law a crime. In the second article, the former president, as alleged to have been similarly unmindful of the high duties of his office, of his oath of office, and in violation of the Constitution of the United States, which again may be deplorable, but not under law a crime. And despite repeatedly repeating the phrases of high crimes and misdemeanors as if that made it so, or simply asserting that an action was a high crime conclusively amongst 11 articles of impeachment, that Congress asserted commission of only one action. One action described specifically as an actual misdemeanor, albeit without presentation of a prima facie case, therefore, which one simply cannot do even with the nuclear device of RICO in a civil action, without being laughed out of court, summarily dismissed for vexatious and frivolous litigation, lucky not to be sanctioned or charged with criminal contempt and loss of legal license. It is clear, or should be clear, that not every crime is a high crime nor misdemeanor meriting impeachment, and one might not expect an impeachment on a slight charge of reckless driving, speeding 20 miles over the speed limit in the Commonwealth of Virginia, perhaps. But certainly, if a member of the military, subject to Article 114 UCMJ, who engaged in dueling would be guilty of a pretty serious offense and shall be punished as court-martial may direct. And in 1828, at least contemporaneously bearing close nexus to the duel between Andrew Jackson and Charles Dickinson, a call for a new amendment was proposed to ban a custom that survived almost to the 20th century, especially in the West and in the South. But it was the conduct that the Congress considered only meriting censure. When in 1838, Whig Congressman William Graves killed Democrat foe Jonathan Silly in a duel. According to the rational and unbiased mind, in impeachment, regardless of the attendant politics, it should be very clear that to pass constitutional muster, its prescriptions are directed against conduct, not status. And an individual, by his words or actions, must have objectively manifested an agreement to participate directly or indirectly, as we find in U.S. v. Ellen, a 1978 Fifth Circuit case. And the proofs or the inference of an agreement to do so is unmistakable. Furthermore, those crimes deemed high and misdemeanors considered to be impeachable may vary with the times, but the essential criminality as predicate remains fixed and invariable if one reads the plain word meaning of the Constitution in Article 2, Section 4. And, sad to say, even abuse of power does not meet that threshold. It is tragic that in our politics, since the first impeachment proceeding, that basic presumption of innocence is repeatedly and tragically ignored, subordinating reason to passion and emotion, and too often by those professing to be rational, reasonable, and above reproach. But the High Court stated as a reminder to all in Brown v. Payton, a 2005 Supreme Court case, thusly, if a prosecutor had stood before a jury and denied that a defendant was entitled to a presumption of innocence, if the judge refused to correct him and failed to give any instruction on the presumption of innocence, if the judge's instructions affirmatively suggested there might not be a presumption of innocence, would anyone doubt that there was a reasonable possibility that the jury had been misled? And to paraphrase Poor Richard, let a hint to the wise be sufficient. This advertisement was authorized by Mike White.